Okay, the new Field Court Tax Chambers Digest contains a number of articles written by members of the chambers. And I've written a short article about the recent tax treaties concluded by the United Kingdom. Basically, over the last 4 years, since the Brexit referendum and since the end of the BEPS project at the OECD, or as I should say, BEPS 1, there have been 12 treaties that the UK has concluded. Now, looking at each individual treaty, you don't necessarily learn a great deal because each treaty is a bargain between the two countries, and you can't always tell whether a particular article was demanded by one country or another. But if you look at a number of treaties over time, you get an overall impression of the treaty policy of that country. And that's what I've tried to do in this article, to have a little look at the treaty policy of the UK. Now, it's important to do this from time to time because tax treaties are significant for a small open economy like the UK. And they're going to be even more significant after Brexit because a number of the provisions of European law that have reduced tax, for example, at source, they will fall away at the end of the transition period. The Parent Subsidiary Directive, the Interest Royalties Directive, they'll no longer apply and they have to be replaced by the provisions in tax treaties. So the UK has, since the 1950s, focused a lot on tax treaties, and they're going to become more important going forwards. I don't intend in this short video to run through everything there, but let me just pick up two maybe significant points, and then I'll leave you to read the article for yourselves. The first article is the appearance in these treaties of the PPT. The PPT is the principal purpose test, and that's been adopted as part of the BEPS project of the OECD as the major anti-avoidance measure to go into tax treaties. And it's being inserted in some treaties by the MLI, the multilateral instrument to implement BEPS, and in other treaties it's being put in through the bilateral negotiations. The UK has had a big say in the drafting of the PPT and is pushing the PPT very hard. Put another way around, it is UK officials who should be held responsible for the PPT, and historically they will probably be judged for having introduced the PPT. Little note, the UK has prime responsibility for having introduced BO, beneficial ownership, in the 1960s and all the problems that that has entailed. And I suspect in 20 years' time, we will look back on the PPT and we will say, those British officials, they should have known better. Anyway, this is going to become, the PPT, a really significant aspect of tax treaty policy going forward, because the PPT will have to be interpreted by both countries to decide whether or not they're going to deny treaty benefits. And I suspect that pretty soon we're going to start seeing disputes and then competent authority procedures and ultimately litigation on the meaning of the PPT. The other point to highlight is rather interesting new development, and that is explicit reference to the OECD commentaries as an aid to interpretation of treaties. The UK has always adopted the traditional OECD official line, which is that you can have regard to the commentaries as an aid to interpretation, including commentaries concluded after a particular treaty has been negotiated and signed. So you might have a treaty signed in the 1990s and a commentary change in the 2000s, and then in the 2020s, a UK court is encouraged by the revenue to look at that later commentary to interpret the earlier treaties. Now, the recent Supreme Court case of Fowler has effectively in one sentence said, it's okay to look at the subsequent commentaries, but that leaves open a whole series of issues, such as what type of commentary. If the commentary merely clarifies, fine, but what if the commentary effectively changes from the previous commentary? Can you look at it then? All of those are issues that are going to have to come up for decision. Meanwhile, a number of the UK's recent treaties in a protocol makes explicit reference to these commentaries, and in particular to the fact that you can look at subsequent commentaries. Now, that raises an interesting constitutional question, because it effectively means that UK officials, without any specific mandate to do so, go to attend meetings at the OECD, where they write changes to the commentary, which are then voted on by officials at the Committee on Fiscal Affairs, and then can impact on the interpretation of existing treaties. Traditionally, changes to the commentaries have not been discussed in Parliament, but if those changes are going to be used to interpret treaties, there's something to be said for the changes being debated in Parliament. Now, traditionally, the supervision that Parliament has given over tax treaties has been relatively minimal, sometimes almost ludicrous to the point of laughter. But at least it is some supervision, and it does require the officials who go and attend these meetings, change the commentaries, to be called to account to explain why the UK is taking a particular position. And that is something that frankly should be welcomed. With those two comments, I thank you for your attention and hope that you enjoy the article. If you don't enjoy it, you're very welcome to write to me at Field Court with any comments, but I hope very much that you will enjoy reading it. Very nice having this opportunity to introduce it to you. Bye-bye.